And I'm sorry, a little petty statute against the constitutional obligation not to allow our Constitution be shredded by allowing illegally cast electoral votes to decide the election. That should be an easy call, but that's not what the call that the vice president made today was.
In a court filing made Wednesday night, the 1-6 committee said there's sufficient evidence to conclude that Donald Trump and co. conspired to commit fraud and obstruction concerning the 2020 presidential election results. But why make such an allegation in a civil case? And what does it all mean? Welcome into TYT's Overruled. I am your host, Adrienne Lawrence. For the first time, the House committee investigating the January 6th insurrection attack on the U.S. Capitol laid out a criminal case against former President Donald Trump. In the filing, the committee's lawyers argue that Trump, his attorney John Eastman, and others could be criminally charged with conspiring to defraud the American people and obstruct an official congressional proceeding. The filing also claims that by pushing this big lie surrounding the election, Trump could have committed common law fraud. Directly from the filing itself, the committee says this: the evidence supports an inference that President Trump, plaintiff, and several others entered into an agreement to defraud the United States by interfering with the election certification process, disseminating false information about election fraud, and pressuring state officials to alter state election results and federal officials to assist in that effort. Now let's talk about why the 1-6 committee is making these allegations here. Remember, this is a civil case, not a criminal one. The 1-6 committee doesn't have the power to bring criminal charges. All it can do is recommend to the Department of Justice that DOJ bring those charges. Well, then you may be wondering, why then is the committee bringing up criminal allegations in a civil case? The committee is making these allegations that Trump and co. conspired to commit crimes because they need to be able to get past attorney-client privilege. As you may know, conversations between an attorney and client are protected, meaning legal authorities can't access those conversations or use them against the client unless there's an exception. And one of the recognized exceptions is if you and your attorney are planning a crime or committing fraud, or your attorney is advising you on either. Under this crime-fraud exception, then, attorney-client privilege doesn't protect those conversations. With that knowledge, let's turn back to the 1-6 committee. So the committee has subpoenaed a number of people associated with Donald Trump, particularly lawyers, including attorney John Eastman. Eastman filed this suit claiming that the conversations with Trump are protected by privilege, and so he doesn't have to respond to the committee. So the 1-6 committee is responding in this court filing, arguing that privilege doesn't apply here because Trump, Eastman, and others were working together to commit a crime. It argues in the brief, as the president and his associates propagated dangerous misinformation to the public, Mr. Eastman was a leader in a related effort to persuade state officials to alter their election results based on these same fraudulent claims. That is, the 1-6 committee is in civil court bringing up these criminal allegations so it can get past attorney-client privilege. What happens next? Well, a judge will determine whether privilege applies, which it probably does not here, given essentially all the criminal allegations that have been alleged here, and if there's supporting evidence, which largely comes from the, 550 interviews that the 1-6 committee has conducted. After the court issues a ruling, assuming it finds that privilege doesn't apply, then the committee can push Eastman to talk and turn over documents, and if he doesn't, refer him to DOJ for contempt charges. Yeah, another drawn-out process. Now, can the allegations that the 1-6 committee has put in the civil filing be used to prosecute Trump for committing a crime? Yeah, I'm sure DOJ could use these allegations and get the supporting evidence, hopefully, so that it can use it against him to actually prosecute him for a crime. But whether or not Merrick Garland will actually do that, we don't know. And we also know that, hey, he's probably definitely not going to do it before the 1-6 committee finishes their work. But, what do you think? Do you think Merrick Garland would actually use these allegations to prosecute Donald Trump? You let me know in the comments below, hit the like or follow button, and thanks for watching.